All rise. This court is back in session. Seated.
All right. So, Wojnarowski, you didn't have any plans tonight, did you? General Wojnarowski, you didn't have any plans tonight, did you?
Well, about 6 I do.
Fortunately, I need somebody to stand in for me. I think Mr. Locker would probably agree with us. All right, Mr. Locker, do you have any other witnesses you wish to offer?
No other witnesses, Your Honor, but I've had murder cases before where my clients insisted on on testifying at sentencing. So I'd like to do essentially a moment at this point with Mr. Daniels.
Mr. Daniels, if you'll come around, please. Help Mr. Daniels pull his pants up, please.
Gloves up here.
Let's get some gloves.
Just left your gloves up here.
It is a common problem that we have with jail uniforms, and shouldn't be in any way construed anything against Mr. Daniels that happened. But Mr. Daniels, come around and have a seat, please. Raise your right hand. It's to the best of your ability, and let's have you placed under oath.
solemnly swear affirm testimony you give in this case be the truth, the whole truth, nothing but the truth, so help you God.
Yes, ma'am.
Mr. Daniels, did Mr. Mitchell and I discuss with you during the recess the fact that you do have a right to testify at your sentencing hearing if you choose to do so?
Yes, sir.
And did we also advise you in regard to whether or not we thought that would be a good idea?
Yes, sir.
And based on our advice, you're choosing not to testify at the sentencing hearing, is that correct?
That is correct.
But you understand you've got a right to do that even if we don't think you should.
That is correct.
And your choice, based on advice, is not to testify.
That is correct.
That's all the questions I have.
All right, just so that we're clear, Mr. Daniels, you know that if you want to testify, that no one can stop you from doing that. You understand that?
Yes, sir.
And there, likewise, no one can force you to testify at your hearing if you don't want to.
That's correct.
All right, thank you. You've talked it over with your lawyer, and this is your informed decision. Is that correct?
Yes, sir.
All right, thank you. If you'll have a seat back with the other. Officer Cox, you may need to assist him and make sure we're not having any issues. All right, Mr. Lockard, any other proof?
No, Your Honor.
All right, I'll hear you. Any the state have any rebuttal proof?
No.
Then I'll hear you in argument. Any argument, Mr. other than what you've already made, Mr. Lockard?
Your Honor, we contend that under 4035-113, subparagraph 6 is applicable, and that we contend our client lacks substantial judgment. Subparagraph 8 in regard to his mental condition at the time. Subparagraph 11, that it was unlikely that a sustained intent to violate the law motivated his conduct. Number 13, which is kind of the coverall, he supported his family. He had no history of criminal convictions. This was not a premeditated crime. He had post-high school college education and trying to be a better provider. And in the sentencing report, pursuant to Tennessee Public Acts 906, a risk assessment was done, and it said that he was a low risk, according to that assessment, to be a reoffender. So we contend on the convictions other than the felony murder conviction, that he'd be a good candidate for probation. We contend that the enhancement factors in this case, the defendant treated the victim, Joe Clyde Daniels, with exceptional cruelty during the commission of the offense. I submit, one, there's no proof of that, and two, we contend that that's an essential element when you're convicted of beating someone to death. The defendant abused a position of trust in the manner significantly facilitated the commission or fulfillment of the offense. We submit no proof on that. Number 5, the defendant had no hesitation about committing a crime when the risk to human life was high. As the court knows, that's not applicable in a murder charge. And we also contend that under the consecutive sentencing statute, (4035-115), the only factor that might arguably be present, we contend is not relevant. Subparagraph 3, which says the defendant is a dangerous, mentally abnormal person, so declared by a competent psychiatrist who concludes, as a result of an investigation prior to sentencing, that the defendant's criminal conduct has been characterized by a pattern of repetitive or compulsive behavior with heedless indifference to consequences. Now, they put on some proof in regard to prior behavior, but they've not introduced a competent psychiatrist who, prior to sentencing, did a study and opines what subparagraph 3 requires. So we contend that he should get probation on all but the felony murder, and that none of the other convictions should run consecutive to the felony murder.
Judge, just to be clear on Mr. Lockhart's argument, the argument for consecutive sentencing is not, the state's argument for consecutive sentencing is depending upon a different factor altogether. Mr. Lockhart is talking about the factor that does require a psychological evaluation determination of his dangerousness. That's a different factor. The factor that we are arguing is that the defendant is a dangerous offender whose behavior indicates little or no regard for life. Those are two separate factors. So we're not required to put on the assessment or evaluation of a psychiatrist for that argument under consecutive sentencing. Those are two separate factors, just to be clear. But with that said, Your Honor, we are asking the court, based on the proof heard today and at the trial, to not only enhance the number of years that the defendant is sentenced to, but to run those years consecutive. And we're talking specifically about the initiating a false report and tampering with evidence. In the initiation of a false report and tampering with evidence, the defendant was the leader in the commission of a crime that involved two or more actors. I mean, the court has heard proof throughout this case that the defendant today, Joseph Daniels and Krystal Daniels, acted together in covering up the death and the recovery of Joe Clyde Daniels. There's no question that he was the leader in this act, and it involved Krystal Daniels. I mean, her trial is next. Just before this sentencing hearing, we set the trial date for Krystal Daniels. 2, the victim, Joe Clyde Daniels, was particularly vulnerable because of age, physical, and mental disability. Now, I understand Mr. Lockhart's argument that that doesn't apply in a homicide case, but there's 5 different convictions here. And in this particular case, the court has heard proof that Joe Clyde Daniels was diagnosed with global developmental disorder and also was the age of 5. Number 3, the defendant treated Joe Clyde Daniels with exceptional cruelty. The state will concede that we have not proven those factors at this sentencing hearing. Number 4, the defendant abused a position of trust in a manner that significantly facilitated the commission or fulfillment of the offense. That, Your Honor, is one that cannot be disputed. It was proven at trial that the defendant is the biological father of Joe Clyde Daniels. The case law is abundantly clear on this, and I'm reading right now from State v. Cummins, 2002, that the defendant, as the victim's father, abused a position of private trust when he killed the victim and allowed Tara Cummings to physically abuse her. The trial court properly applied this enhancement factor. That is huge in this case because Joe Clyde Daniels was the biological son of the defendant. And yes, he killed him. Not only did he kill him, he has hidden and secreted the body, and he caused on April the 3rd and 4th one of the largest searches and manhunts in the history of Tennessee. The number of resources that were involved in finding Joe based on the initial false report of the defendant is unbelievable. If we were to do an economic assessment of the cost, and nobody cares about the cost because the folks that were looking for baby Joe were happy to be there, but all of that came about because of a false report initiated by the defendant. I mean, that's what happened. And he abused his position of trust over baby Joe. Finally, the defendant had no hesitation about committing a crime when the risk to human life was high. I mean, Your Honor's heard the proof of trial. That is clear. And I will go back to my final argument for consecutive sentencing, which is that the defendant is a dangerous offender whose behavior indicates little or no regard for human life. It is well documented throughout the medical records that we've provided to the court today for 12 years that the defendant is dangerous. He admits he's dangerous in these medical records. He even states to his case manager that he scares himself when he has those homicidal ideations. He scares himself. This is a man that was going to eat someone's face off by his own admission. Not only is that documented in the medical records, he says it to Detective Daniel. This is a man that was planning to bomb his father and stepmother's house. That's documented in the medical records. This is a man that threatened to tie his stepmother to a bed and beat her. Documented his own admission in the medical records. This is a time bomb. He was a time bomb waiting to go off, and unfortunately, he did go off, and he killed baby Joe. And Mr. McGranahan had it right. He snapped. He got mad from the proof in trial, and he snapped and killed baby Joe. But he snapped before. He's put his hands through glass. He's punched holes in the wall. He's threatened to kill himself. He's tried to kill himself. He's ideated on killing folks for 12 years, and it came to fruition. And that's why this consecutive factor should be considered and implemented, because he is a danger, and he's a threat. He has no regard for human life. Thank you.
This court is required to impose the sentence in this case according to the laws of the state of Tennessee and the statutes enacted by our state legislature. I would first address the fact that I've already stated on the record, but I'll state it for the purposes of my ruling in total. In count 1 of the indictment, the defendant was charged with premeditated first-degree murder. The jury found him guilty of second-degree murder. In count 2, he was found guilty of committing a felony murder, the murder in perpetration of the felony of aggravated child abuse. And in count 3, he was found guilty of aggravated child abuse. As this court has previously stated, it is my opinion and my ruling that those three must necessarily merge because of the second degree merging with the felony murder charge, and the felony murder charge being based upon the aggravated child abuse, then those would all merge. And the sentence imposed by this court is life in prison. That is the sentence that's mandated by the finding of first degree murder or felony murder, where the state did not seek life without parole or the death penalty. So that will be the sentence on those three charges as they merge together will be life in prison with the possibility of parole after 51 years. Mr. Daniels is 31 years old. That means he would be eligible for parole at the age of 82 years. Count 4 is the initiation of a false report. That is a Class D felony and therefore is a Range 1 offender, which the court does find that Mr. Daniels would qualify as a Range 1 offender for purposes of sentencing. And the sentence range on a Range 1 offender for that Class D felony would be 2 to 4 years. Count 5, tampering with evidence, again, is a Class C felony. That carries the sentence, a possible sentence for a Range 1 offender of 3 to 6 years. So, having found that those first three involve a merger and that type of a sentence, then the court will have to set the sentence according to sentencing considerations. And that is set forth in 4035-103 of the Tennessee Code. And sentences involving confinement should be based on the following considerations. A, confinement is necessary to protect society by restraining a defendant who has a long history of criminal conduct. B, confinement is necessary to avoid depreciating the seriousness of the offense, or confinement is particularly suited to provide an effective deterrence to others likely to commit similar offenses. Or C, measures less restrictive than confinement have frequently or recently been applied unsuccessfully to the defendant. The sentence imposed should be no greater than that deserved for the offense committed. Inequities in the sentences that are unrelated to purpose of this chapter should be avoided. The sentence imposed should be the least severe measure necessary to achieve the purpose for which the sentence is imposed. And it goes on to cite some other factors. Court, in considering all of that, is required to consider the evidence at the sentencing hearing, the evidence at the trial, and other factors which are introduced, including the mitigating and aggravating factors. So moving to the aggravating factors that were cited by the state, I'll consider those first. The aggravating factors that I found to be applicable was that the defendant was a leader in the commission of offense involving 2 or more criminal actors. Again, we're dealing only with the false report and the tampering with evidence. At least as to the false report, clearly Mr. Daniels and Mrs. Daniels engaged according to the finding of the jury. They engaged in a false report of the missing child, which led to this massive manhunt that dominated Dickson County for a long time. And I find that to be a factor that does apply. Number 2, the victim was Joe Clyde Daniels, was particularly vulnerable because of age, physical, and mental disability. Clearly, the evidence at trial was overwhelming that this child was a special needs child that was semi-verbal, and he was unable to do some things for himself, but he was a child that was particularly vulnerable because of his age and his mental disabilities. 3, the defendant treated the victim with exceptional cruelty during the commission of the offense. Again, I found that to be an applicable statement because the testimony was the confession of the defendant, and I'll use his own confession as the basis for that finding. And that confession stated that he beat this child repeatedly, and that picked him up and threw him down on a coffee table and inflicted what were later to be fatal injuries on the child. So by his own admission, he beat him for a substantial period of time. Number 4, the defendant used a position of trust. And I would state also that there is case law that substantiates that beating someone repeatedly that leads to their death is in fact an aggravating factor, or can be an aggravating factor under that statute. And I'm referring there to State of Tennessee versus Matthew Reynolds, Alfonso Richardson, Cynthia Diane Skipper, and Derek Vichito. And that case was appealed, and a part of that was for consecutive sentencing, which I'll deal with. But in that, the court found that the excessive beating, exceptional cruelty and beating of the victim that resulted in death was found to be something that was a factor for enhancement, and I find that to be the case in this case. That the defendant abused a position of trust that in a manner that significantly facilitated commission and fulfillment of the offense. Again, he was the father of this child, and I believe that that is an applicable enhancement factor as well. The defendant had no hesitation about committing a crime when the risk to human life was high. Mr. Lockhart argues that that is a factor that, in his opinion, should not apply because it is a part of the crime of committing felony child abuse that leads to death, and I would agree with Mr. Lockhart. I don't think that that can be considered by the court as an enhancement factor because it does essentially contain essentials of the actual crime that he was committed, that he was found guilty of on those two. But I'm not considering that on those two. I'm considering it for the question of whether or not he made a false report and tampered with evidence. And it doesn't seem to me that those two, that factor would necessarily apply to those two. So I do not find that number 5 would be applicable. As to the mitigating factors cited by the defendant, running through the entire list, the mitigating factors set forth in 40-35-113 are that the defendant's criminal conduct neither caused nor threatened serious bodily injury does not apply. The defendant acted under strong provocation does not apply. Substantial grounds tending to excuse or justify his criminal conduct, though failing to establish a defense, do not apply. The defendant played a minor role does not apply. Number 5, before detection, he compensated or made a good faith effort to compensate does not apply. Number 6, the defendant, because of youth or old age, lacked substantial judgment in committing the offense. I observed the interview with Mr. Daniels. I've read through a great deal of the medical records and the mental evaluation situation, and in my opinion that does not apply because of the fact that there was no indication that he actually suffered from an illness that would be sufficient to justify the offense, even though it was not, that he lacked substantial judgment in committing the offense. The defendant was motivated by a desire to provide necessities for his family does not apply. The defendant was suffering from a mental or physical condition that significantly reduced the defendant's culpability for the offense, although voluntary intoxication does not apply. There is evidence that he had a mental or physical condition or mental condition that did affect him, and the history that the state has put on at sentencing is that he's dealt with this most of his life. Mr. McGranahan has pointed that out in his pre-sentence report. I do find that to be an applicable mitigating factor. Number 9, he assisted the authorities in uncovering the offenses does not apply. He assisted the authorities in locating or recovering property does not apply. Number 11, the defendant, although guilty of the crime, committed the offense under such unusual circumstances that it's unlikely that a sustained intent to violate the law motivated the criminal conduct. I do not believe that is an applicable in view of the fact that there is a history of conduct by this defendant where he reacts in anger and violence and threats of violence. That it does not seem to me that this was an isolated event, so therefore I do not find that that applies. So I found 1 mitigating factor and 4 enhancement factors. As a result of that, the court finds that the sentence to be imposed in count 4 for the initiation of false report should be a sentence of 4 years, and that the sentence for tampering with evidence should be a sentence of 6 years, and that those 2 sentences should run concurrently with one another. Question then becomes as to whether or not those sentences of 6 years should be running consecutively to the sentence of life in prison, and that becomes a much more difficult. That becomes a more difficult dilemma for the court in trying to impose the appropriate sentence. That statute that we're dealing with is 4035-115, which deals with multiple convictions, and the court may order sentences to run consecutively if the court finds by preponderance of the evidence that, one, the defendant is a professional criminal. He is not, so the court does not find that. The defendant is an offender whose record of criminal activity is extensive. That does not apply. Again, I agree with Mr. Lockhart that the defendant has not been proven to be a mentally abnormal person so declared by a competent psychiatrist. But the state is relying upon, number 4, that the defendant is a dangerous offender whose behavior indicates little or no regard for human life and no hesitation about committing a crime in which the risk to human life is high. The court does find that to be a factor. In this case, the evidence is clear that Mr. Daniels has had a history of violent tendencies and violent propensities. So therefore, that is a factor which the court can consider. But in weighing this overall, my main interest is to ensure that the defendant receives a fair sentence and that the record is clear that there are no errors that might lead to an appellate court having to address these issues. And in this case, there's been much said, much ado about having to have this young man, A.N., to come into court and testify as a witness. And I may be right about my ruling. I may be wrong about my ruling. But I am not going to run these sentences consecutively, and thereby it essentially renders moot the question of whether or not I was correct in allowing this young man to be avoid having to come in and testify about this traumatic event. My belief is that a 51-year sentence on a man of 31 years is sufficient under the circumstances. I expect Mr. Daniels to probably will die in prison under this sentence. Likely, not many people live beyond 80 years of age in prison, I wouldn't think. But I would rather err on the side of ensuring that this young man is not required to go through that trauma again and not run them consecutively than I would to impose a 6-year sentence tacked on to a 51-year sentence. So for that reason, my ruling is that these sentences will run concurrently with all other sentences. Any questions? All right, thank you. That is the judgment of the court in this case then. That concludes this hearing, and before we begin then resume our regular call on the docket, we'll take just a very short recess to allow everyone to clear out. You need to stretch your legs down.
What's the recess?
Have you got something else, Mike?
A couple of Hispanics who are arranging these interpreters on there.
I want now to repeat that.
The interpreter's been sitting in whatever room those people sit in.
Have you got a client that needs an interpreter?
I don't care if he sits there all day.
No, I
It's a
will.
female.
Oh, yeah, it's committed. Yeah, I like her.
Let me know as soon as you can get ready.
There is no court protection custody in prison. When he's outside, he's the only man you got to run on. He's around guards when he's outside, so he should be fine. I've only had one time 37 years. Injured, he's back in prison. You're right, and I'm breaking the retarded. So it's a lot safer than you might think.